Now, moving to the eastern part of Nigeria, the leader of the indigenous people of Biafra, IPOB, Nnamdi Kanu, has indicated his intention to pursue an out-of-court settlement regarding the terrorism charges brought against him by the federal government. During the latest court hearing, Aloy Ejimako, counsel to the detained IPOB leader, informed Justice Binta Nyako about discussions with Chief Adegboyega Awomolo, senior advocate of Nigeria, the prosecuting counsel, expressing the defense interest in settling the case outside of court. Awomolo responded that he lacks the authority to initiate such a settlement, suggesting that the defense should approach the Attorney General of the Federation, who holds the power to seek out-of-court resolutions in legal matters. In response, Ejimako referred to Section 17 of the Constitution, which he argued supports reconciliation efforts.
The Federal High Court Act is simply what the National Assembly enacted. The National Assembly enacted at that Section 17 that reconciliation shall be promoted by the court between parties before the court, criminal or civil. So it so happened, and it came to pass that today that very issue was briefly considered in open court. So it is either for the court in its wisdom to initiate and direct that parties do go and engage in such conversation, which the court did indirectly by not opposing it and by even suggesting it, or the parties themselves, either party, either the defendant or the prosecution, can initiate it. So a situation where the Attorney General of the Federation took steps under Section 174 of the Constitution, which is very similar to Section 17 of the Federal High Court Act. He took that position to discontinue the prosecution of two very high-profile cases in this country. The first one concerning Yele Show, and the second one concerning Bola. So these things are not unusual. So if they do occur as a conversation in open court, it's just as a matter of course. So people might wonder why such a situation should not apply to the and that is what they are doing.
Member of the House of Representatives Ikenga Ugochinyere also commented, urging the president to intervene in the matter.
It has come to the point where national interest is supposed to come into play. I thank the lawyers for holding for this particular moment. And I appreciate what the judge said, which is what we have been coming here saying from day one, that we cannot resolve this thing through the judicial angle at this moment. And we have said from day one, both from the moment his house was raided, from the moment he was extradited from Kenya and so on and so forth, that numerous courts in the land have declared those actions null and void. So why are we still here? And the federal government has also adopted that same approach in the major island issue where they filed discontinuance. They have also done it in Soweto issue where they filed discontinuance. And when we had all these issues in Niger Delta, there was reconciliation and discussions. When we had all these issues, even in Northeast, there was the same issue. North Central, there was the same issue. So how come we have gotten to the Southeast, then nobody is having this conversation? So I'm pleased with the decision of the Federal High Court today. It's already there under Section 17, and it's also there under Section 174 of the 1999 Constitution that government can discontinue. And grounds for discontinue is national interest, public interest. And I represent the people. Like what my brother, other lawmakers from the Southeast, we can't go home most of the time. There's insecurity everywhere. People are being killed. Businesses are affected. Foreign remittance to our place is going down because people are leaving those rural areas. It's a matter of public interest and national interest that government considers this option provided under Section 17 of the Federal High Court Act and Section 174. And the ball is now in the court of President Bola Ahmed Tinubu government. As somebody who wants to renew interest, it's time to renew interest in the Southeast by opening the gate and let Martin and the Kanu go. And let's now open the conversation for addressing the challenges that led to this issue.
Justice Nyako stated that if the Attorney General of the Federation approves the request for out-of-court settlement, the court can be informed accordingly. Earlier in the proceedings, the court dismissed an application by Kanu challenging its jurisdiction to adjudicate on the charges brought against him by the federal government.